Welcome to Soft Apocalypse Bar Review. I'm Kimber, and I'm your host through this parade of horribles that is known as the bar exam. And today, one of the things I wanted to talk about with you is how to deal with the lack of actual tangible scratch paper as you take the remote examination in October. And there are a lot of states right now that are requiring students to use ExamSoft to take their bar exam on a computer, but unlike the way that it would normally be administered, you're not going to have access to any kind of writing implement. You're not going to be able to write any kind of diagrams, make outlines, or otherwise notate or highlight or make timelines in your materials. So this has been a big problem, and it's basically one of the things that most people have really wondered, how do you deal with this? And I know bar prep companies have been struggling with this as well because there really is no good answer for you. Never in the history of the universe of bar exams in America have we ever had to administer a bar exam to 30,000 people all at once solely online. And there's a couple issues. It's not just the essays, as you might imagine. It's also the MBE. So today I'm going to try and give you some pointers to the best of your ability to try and use the virtual scrap paper, which is one of the things that you'll actually be able to use based on the rules that have been put out from some of the states. Now, the first thing that people are wondering about when it comes to the lack of scratch paper is, how the heck am I going to do the MPT, the multi-state performance test? Now, this is a great question because typically these libraries of materials that you get can have up to 40 pages. Usually there's a task memo. There might be a separate task memo to tell you to do something that's not a letter or a memo. There could be various pieces of evidence, statements from witnesses, case law, bits of legislation, literal images. There could be any number of things that you have to file through, that you have to normally you would be able to rip the book apart, organize it however you want. You would be able to actually take things out, highlight, circle. You could write your own notes in the margins. You're not able to do any of these things. Now, every single state that is doing a performance test they've not all given us answers on whether or not they're going to even allow virtual scrap paper. And again, what does that mean, virtual scrap paper? It just means you're going to be able to have a split screen. So you'll have basically a PDF of the MPT that you'll be looking at, and then you'll be able to open up another window on your computer. So you'll be able to have a split screen. Now, I'm looking at you on a MacBook Pro that's a 13-inch. So this isn't this is not a very useful kind of thing, having the virtual scrap paper, because what I'm going to be talking to you about today is really based on the New York rules that have come out. And based on those rules, they are going to be allowing you to have a few little implements like highlighting, cutting and pasting. Unfortunately, you're not able to cut and paste anything out of the MPT. So the only thing you're going to be able to do on the MPT literally is have them be side by side. So really the only way that you'll be able to tackle this, it's a huge undertaking, is you have to completely overhaul your approach to doing the MPT. Because the way that we've all been taught, the way that bar prep immemorial, the way that every law school would have trained you to do it, is you literally sit down, you start taking notes, you highlight in there, you write things in the margins, you might even rip the book apart and reorganize things so that it makes more sense to you. But you can't do any of those things now. You literally have to take more of a linear approach, and the only way you'll even know what's relevant is if you read the entire case file. Now, I think that one thing people are a little confused about when it comes to the MPT is that they think they have to race through and just start writing right away. And that's where a lot of folks go astray. So I think we can hew to some of the areas that a regular MPT would hold true before we get into the new things. So let's just talk about the regular MPT. With respect to the regular MPT, there's several different types of formats that we see now. It used to be it was largely going to be either a letter or a memo. We've seen things like legislative leave-behinds. We've seen where they just ask you to do the argument section to a longer brief. We've seen various things where they actually want you to write a piece of legislation. I mean, that's more rare, but for the most part, one of the things that a lot of students do not give enough credence to is the instructions, what they tell you to do. So the first thing that you want to fold into your practice is you want to make sure that you are reading the instructions thoroughly. Do not race through that. So likely the instructions are going to come in the form of a memo or a letter from a supervising attorney, and you're an associate at that firm. Or somebody has come to you, they've assigned you this client. So you have to make sure you understand what role it is you personally are playing. Because a lot of times, and I've seen this happen too many times when I've graded people's practice essays, you are in law school mode as opposed to associate mode. Now remember, when you are working in a law firm, and especially if you're a first, second, third year associate, you're never doing anything by yourself. You're not writing an entire memo for the most part. You're not writing an entire legal brief. You're not writing a bunch of documents that are just solely your work product. Typically what's happening is you're being given part of an assignment. So you might be told you have to write the statement of facts, or they want you to write a timeline of important facts, or they want you to write just the argument section for a larger brief. Now, what I want you to really focus on when you're reading these instructions is make sure you're clear on what it is you are supposed to be doing, not what everybody else is doing, what you are supposed to be doing. Because I've seen too many people lose points just on the format alone because they decide they're going to write a giant memo heading when it's not really a memo, or they decide they're going to write I've actually seen some students come in and write a letter to the supervising attorney saying what an honor it is for them to be in this position and they're going to do their very best job. Don't try and get cute with the MPT. You're not getting points for that. You have to treat the MPT as if it were an actual job that you actually had and you're actually doing this job. And if you fail, you get fired potentially, or you get reprimanded, or you get in trouble. It's not just about not getting a good score on an assignment and do better next time. It's go back and do it again, or now you're in trouble because you're holding up the whole situation, or you're causing troubles for your client. So you have to do exactly what they tell you. I don't care how robotic, how tedious, how by the numbers it feels, but the MPT is the one time on the bar exam that you actually get graded for stupid stuff. You get graded for just following the directions. You get points for just giving them exactly what they want. If it's a letter, structuring it in a letter format. If it's a memo, writing just the bare minimum of things that you need in that memo. If it's an argument section, likely what they're going to do is give you a second task memo that says, hey, at our firm, this is the format that we want you to follow. Follow it. Do not get cute on the MPT. People get in so much trouble when they think they're going to do their own stuff, or, oh, they only asked me for the argument, I'm going to give them the facts, or they asked me for the facts, I'm going to give them an argument instead. Do not get cute on the MPT. This is not the time. The bar exam is not a time to get cute in general. It's not a time to like stroll out and start showing people all the random stuff that you know. You have to do what you have to do to pass. And largely that comes down to following directions and knowing what strategies are to get you the most points. So number one, you can get up to a quarter of the points available on the MPT just by following the format and structuring your answer accordingly. Make sure you read both the task memo and any additional task memo that tells you how to structure your answer at least twice. Do that. Make sure you are 100% clear. Now, when it comes to structuring your answer in your virtual scrap paper, instead of just putting a whole bunch of text that you've gleaned or that you're feverishly retyping, what I would recommend for you to do is immediately start formatting your answer the way that the question says. You must format it that way. So if it is a memo, make sure you put your memo heading in the correct way. If it's a letter, make sure you address it to the correct people. And if it's going to be a larger part of a different assignment, make sure that you've got that structure all ready to go. So instead of outlining per se, have the structure. I don't know that you're really going to have time to outline the way that you normally would. And this might be controversial, but honestly, I just don't see it happening that you're going to be able to do an outline in the same way for the MPT, because you're constantly going to have to be going back and forward through the pages. So what I would definitely recommend is, once you are clear on what the assignment is and what the structure is, the first thing you do is go to your scrap paper and set up the format as much as you can. If there's headings that you have to put in there and you don't know what the headings are going to be, at least make sure that you've followed that. You can go back in when you know what the headings are supposed to be, but make sure that you have that in your scrap paper. So instead of outlining, we're going to just try and kind of on the fly create the document that we've been assigned to create. So the next thing that I want you to really, really think hard about is, when they give you certain directions about how to structure your answer, make sure that you're taking that to heart. For example, sometimes you'll get a directive to make effective headings. And when they say effective headings, they really mean that they should be, the supervising attorney should be able to tell the argument that you're about to make solely based on that heading. It doesn't mean that you just write facts or random fact I pulled out or something like that. Or just like part of a rule. You have to look at the way that actual legal documents are typically written, and the headings. If you look at any kind of complaint, any kind of pleading, any kind of legal brief, the headings typically, basically, they're spoiler alerts. They tell you exactly what you're going to argue, but it's a summary of exactly what you're going to argue. So make sure you're 100% clear that when you're using headings, that they are not just vague, random things that don't tell me anything. I should know what I'm about to read by looking just at that heading. I should know that when I get into this bit, oh, this part right here is where they're talking about this particular rule of law that we are saying that we didn't violate, and here's why, and here's all the support. Another thing I want you to take care is, if they tell you that you have to use cites, don't freak out and start being like, oh no, I don't know my blue booking. It's all gone out of my head. You're not expected to blue book. I mean, literally, when they say use cites, they mean just literally mention the case. And you could even mention state versus so-and-so. That's plenty. Just put that in parentheses and move on with your life. If you actually have a page from there that you want to bring out, that's fine too. But the main thing is, if they say you need to cite something, make sure that you're citing it, but do not waste time trying to blue book. That is not going to get you extra points. They're not grading you on your blue booking. They're grading you on your ability to follow the directions, which is, oh, they put what the case name was. That's what I was looking for. I just want to be able to find where this support is coming from. Another thing that a lot of folks struggle with just in the regular MPT is you spend too much time reciting facts that you don't need to do. You only need to talk about the facts where they're relevant to support your argument. And so, for example, if you have an argument section where they're telling you do not recite the facts, the reason they're saying that is because somebody else has already done this. And the only facts you need to bring in are the ones to support your particular argument. So if you have a situation where you have a multi-factor test, and it's almost always a multi-factor test, there's going to be some kind of situation where your client comes in, they did not get a result that they wanted from some government office or organization, or like maybe like the IRS or something, and there's a multi-factor test that you have to demonstrate in order to get the result that you want. And your argument section is based on the federal government did not apply the factors properly. We're going to show you how to apply the factors properly. So in that case, when you're setting up your MPT, you're going to want to, the first thing you're going to want to do is make sure that you understand what all the factors are. So get used to reading different types of MPTs so you see what kind of an MPT it is. And a lot of them are these multi-factor things where you literally have to go through, pluck out all the different factors from the case law, and then show the facts that you have to support those factors, where they're neutral, or where you don't have the facts to support it, but that particular factor isn't dispositive in any way. So make sure that you're clear on how to pull those different factors out. And that really just comes down to understanding, first of all, what the key question is that you're being asked to do. So when you have an understanding of what your task is and what you're being asked to do, you can more quickly go through the case law to pull out the rules that are relevant, and then you can go back and start reading for content to pull out the facts that are going to support. I don't know that you're necessarily going to have time to read the entire library, and I don't know that anybody ever actually really does read the entire library. I think the most important thing is the first thing that you really want to do is figure out what are the rules of law that you're going to have to apply. And you're going to get those typically either from a potential, either they're going to give you some kind of a piece of legislation or some kind of code. They might give you a page from a code book, and then they'll give you 3 or 4, maybe only 2 or 3 cases, and a couple of the cases are going to support what you need to support, and a couple of the cases are not going to support what you need to support. When you have a situation where you're given 2 different types of case law, one in favor and one against, that is your cue that you're going to have to make, you're going to have to anticipate what the opposing arguments are going to be, and you have to neutralize them. And that's when you'll start looking for facts. So my advice to you when it comes to doing an MPT without scratch paper is just completely rethink how you're going to approach the MPT. And instead of feeling like you have to spend 45 minutes reading the entire library, first things first, figure out what the format is. Sketch that into your virtual scrap paper. Then we have to figure out what the guiding rules are, and we have to figure out where they are. And you can usually tell because the library will actually have kind of an index to tell you what it is. And if you see an index that has a page from a code book for a municipal code or some kind of an ordinance or something, and then you'll have various case law, you can almost guarantee that you're going to have to read those cases to figure out how that rule is being interpreted. Or if you just see a piece of code or maybe one case or maybe 2 cases, the likelihood is you're going to have to pluck the rule from those cases and then apply the tests to the facts that you have. So the first thing you're going to want to do is make sure you're clear on what the rules are, and then you're going to put that into your virtual scrap paper. That's where you're going to go in there and you're going to put that in as part of your headings, because you're going to need to know what the rules are. So usually when we're dealing with MPTs, there'll be kind of an introductory area before you get into the headings where you go. If it's a multi-factor test, for example, which a lot of these are, first you're going to do a summary. You're going to say, okay, here's the deal. This is the rule of law we're going to be applying here. This is the rule from this case, and remember, you're going to cite it if you're told to cite it. And based on this rule, there are factors. It's a 5-factor test, a 3-factor test, a 10-factor test, whatever. You don't have to enumerate each factor in your summary. Just say, there's a multi-factor test that applies to these kind of things, and it's our position that the factors are heavily in support of our client. Next, that's when you're going to start going into the different factors. So if there's a multiple factor, there should be a heading for each one, and that factor should be explained and then applied. So if it's a factor in support of a certain thing, you're going to say, this factor says this, these facts support that. That's literally all you're going to say. And that's what you're going to be doing for your entire organization there. So first things first, we're going to find out what the rules are. Now we're going to go back in and we're going to try and figure out what the facts are that either support or oppose or are neutral. And you're gonna want to, what I would recommend that you do, instead of trying to write fully in your scrap paper as you're going through, once we understand what the rule of law is that we're going to apply, and we have a basic kind of organization, like if there's different factors or if there's different prongs of a rule or something, make sure that you've sketched those out and made full effective headings. The next thing we're going to do is we're going to go through and we're going to start looking at the various pieces of evidence that give us facts. Now, the case law that interprets those things are not necessarily the facts that you need. So there might be a letter from your client. There might be a narrative or some notes or something like that. The first thing you're going to want to do is you're going to want to look at the piece of evidence that's going to apply to each of the various factors. So make sure that you're clear on what those facts are, and then try and kind of like make little bullet points within each different heading. And again, like I say, there could be as many as 10 factors. There could be just 3. But for each prong that you have to address, go through and just sketch in the bullet points in your scrap paper so that you're clear on what you're going to have to flesh out. Only after you have gone through every single prong and every single detail that you think is going to go to each of those various elements, that's when you're going to go in and look at the case law and really kind of dig in and kind of read for context to see which of these cases support. Because usually there'll be analogous cases and there'll be distinguishable cases. The first thing you're going to want to do is you're going to want to make the claim of how these facts from this case are analogous to your case, therefore it supports the prong or the factor or the rule that you're trying to show. The next thing, you do not want to lose points by failing to give the distinguishable stuff, because you don't want to ignore bad facts. There's always going to be bad facts, or there's going to be neutral facts. You have to address them. You cannot ignore them. You will not get full points on the MPT if you are ignoring facts or not adequately neutralizing them, or in some way making sure that the reader knows that you saw the bad facts, you acknowledge that they're bad, but they're not dispositively bad. They're not ruining your case. And the way that the MPT is designed, you're never going to have facts that are so bad it's going to sink your case. Almost never. There's almost always going to be enough evidence that weighs heavily in favor of your client so you can make a strong argument for them, while also acknowledging, yeah, these facts are neutral at best. These facts aren't great, but guess what? You don't need all the factors. Maybe 5 factors is enough, maybe 6, and we've got 7 here, so we're good. So when you've gone through and distinguished and found what's analogous, you want to make sure you go back and look at the cases where your facts are distinguishable. So either it's distinguishable and it's good, or it's distinguishable and it's bad. Because they can be analogous and good, or analogous and bad too, if it depends on how the cases are, but usually the cases are fairly brief. So make sure that you are analogizing and distinguishing properly for each section before you move on. So when it comes time to fully flesh everything out, you should still have time that you can go into, you can then cut and paste everything that you've made in your sort of like sketched out area for whatever you're doing, if it's a brief, if it's a letter, whatever, and then you can transfer that. Because as far as we know, cutting and pasting is allowed from your scrap paper into your answer section. So in order to not have to deal with losing time or being incomplete or not having time to transfer, the only thing I'm going to recommend that you do in your virtual scrap paper is basically have the sketched out bare bones version of your task with all the various headings. It's in the correct format. You've identified the correct rule or rules of law that you have to apply. You've taken out all the various elements that are relevant. If it's prongs, if it's factors, whatever it is, you've taken them out. You've made effective headings for each one. You've gone through. You've found bullet pointed facts that apply to each of those. You've gone back through the case file to look at the case law to identify the cases that support you, the cases that are analogous, the cases that are distinguishable, and you've scratched and noted that all in. Once you've done all of those things, and you can achieve this within the 35 to 45 minute reading and outlining time, at that point, do the full cut and paste and put that in your answer. So now that the only thing we're doing in the virtual scrap paper is making our bare bones sketched out assignment. Then we're going to cut and paste onto the actual answer, and then we should still be able to do a split screen between the library materials and your answer. So now you can go in and you can taking it factor by factor, or element by element, or prong by prong. You can start with each individual section, and you can scroll up to the part of the MPT library that is that part of the case or that part of the facts, so that you can make sure, just kind of scanning across, okay, now I can flesh out the facts, now I can flesh out the case. So basically, yes, you are going to be doing a split screen, but you're only going to be using the split screen once you've actually created the full and complete bare bones version of your answer. So you'll be able to literally have them side by side so that you'll be able to just like, instead of wasting time, this is what I don't want you to do. I don't want you to waste your time going like in a linear fashion, going through every single document and then verbatim typing tons and tons and tons of text, and then somehow coming to the end of it and not having a properly formatted answer, not following the directions, and not actually really doing a very good job of answering the question, which is why we're not going to read the whole thing. We're just not going to do it because we don't have time with this inexplicably difficult format that they've set for you. You do not have time. And honestly, as an attorney, you wouldn't necessarily read all of this stuff like word for word either. You'd be digging around in there. You'd be looking for like, oh, let me identify the rule of law first. Let me look at the case law. Let me see which things apply before I start applying them to my facts. So once you're in a position that you have that sketched in thing, and like I say, you should be able to take a full 45 minutes to create the bare bones sketch of your answer before you cut and paste it, and then we're in a position where we're just kind of like taking it step by step. This is why it's so important that you make that bare bones version, because you're going to be scrolling back and forth on one side, which is like, I'm going to look at the case law again to see what's analogous. I'm going to look at the facts again to make sure I've got them all, and then just move on. So your MPT, you'll be addressing it more linearly based on what the way that things are organized. But when you originally make your first attempt, your bare bones version, you're not going to do that linearly at all, because there's just no way to do it. So hopefully that has given you some kind of guidance on how to approach the MPT when you're not able to actually do anything other than have a split screen. I think it really comes down to the mental and psychological approach. It's a different approach than what we've been taught. In fact, everything about this remote exam is different than your bar prep. It's different than law school. It's different than everything. It's not the way law is practiced. It's never going to be the way law is practiced, because law is open book, and it always has been. That's why the MPT is supposed to be a true and accurate kind of assessment of a lawyer's skills. But the problem is, I don't know any attorney who doesn't take notes. I don't know any attorney who doesn't make highlights or like write things in the margins or whatever. Nobody does this. It's never been done. So that's why you have to kind of like radically rethink your entire approach. Like whatever MPT video that you were given that tells you, like you have to unlearn that. You have to unlearn what you were taught about how to approach the MPT, because the only way to do this is literally to focus on the form before we get to the form and the function before we get to the meat of it. That way you have a guide. That way it's easier for you to be where you need to be. One other thing I would recommend while you're going through finding these key facts, make sure that you put a page number in there, or a paragraph, like a page and a paragraph. That'll make your life much easier too, because you'll be able to see, okay, page 4, paragraph 3, that's where I got these facts. Page 5, paragraph 7, that's where I found this thing in this case. So make sure that you are taking these little notes when you go through. But that's really the only way I think you can adequately apply an MPT to this particular format. There's no other way to do it. So please put your questions in the comments, or feel free to tweet at me. I'll be happy to talk you through it if you've got other kinds of formats that you're worried about. But the next thing that I wanted to talk about is, how do we deal with the MBE, the multi-state bar exam, the multiple choice, without being able to write, diagram, make timelines, sketch, whatever. So according to the New York rules that came out this week, you are able to highlight, and I'm assuming that for anybody who's taking a UBE test, the rules will be the same. It's possible that's not the case, but based on what New York is saying, I would bet that is how it's going to be administered, since most everybody is going to be using ExamSoft. It's going to be the UBE materials, so I'm pretty sure this is probably what's going to be happening for everybody. So you will not be able to highlight within the MPT, but according to the New York guidelines, you can highlight in the questions. So, and that goes for essays as well. So the essay prompt, you can highlight in there. The and that and apparently that's what they say that you can do for the MBE too. So you are able to go into the fact pattern in your MBE, the answer prompt. You'll be able to go in and use highlighting. Now that's time consuming. And it also begs the question, am I highlighting everything to the point where it's not going to be valuable either? So again, we have to completely and radically rethink how we're approaching these questions, because we have been taught, and everybody's been taught, and Bar Prep has taught you to write things in the margins, to circle things, to square things, to underline things, to write notes, to make a timeline, to diagram all of these things. And you just can't do it. You're not able to write anything. You're not able to notate anything. The only thing you literally can do is cross out answers. They are allowing you to cross out answers that you don't want to consider. Great. And you can highlight. Now, allegedly, you will have virtual scrap paper for the MBE. So even though you're not able to diagram the question itself, you will have access to the virtual scrap paper feature, so you can make, you're supposed to be able to make notes using that. So if in fact you are able to have access to the virtual scrap paper with respect to the MBE, what I would recommend is, because there are a few key things that you would need to be diagramming and things, and it's usually future interests. It's sometimes dealing with property, mortgages, anywhere there's a date. So, and I know that there are those of you out there who basically like highlighted every second word, because I bought your used books. I've seen it. I saw one that looked like a pride parade because it was every color like the whole page was completely highlighted. Everything was highlighted in different various colors. So we don't have time for that, and you don't have time for that, and it's not valuable. So the only time you really are going to be able to spend time using the highlighting feature is literally dates, parties' names, and I would say particular actions of interest that happened. So you'll want to go in at least at the first, like, don't do it all the way throughout, but I know it's very difficult to keep parties separated. So I would recommend, especially when it comes to wills and there's 5 different people involved, or at least 3 or 4 parties who all have various claims or competing claims or whatever, I would definitely recommend that you just highlight the first instance that you see of a party name. And if there is a relationship that you need to know, highlight that. So like Abby, daughter of Betty or something. Another thing that you could do is not highlight. One thing that I've seen as we've been going through this kind of rigmarole is that people have been using the highlight feature in their various practices, using their question banks or whatever they have access to in their various bar prep materials. And some people have noted that it's taking much longer to highlight than if they had just read and tried to answer the question. So again, that's where the virtual scrap paper comes in. Just get used to typing, like, as you go through, like have that split screen there, because they are going to give you the ability to go forward and back, so you will only have one question. So the good news is, very similarly to what a question bank would look like, the online questions, and I know not everybody has access to online questions, but for those of you who do have access to an online question bank, you're going to need to work solely within your online questions. I know that you have these huge books of questions. You can still use those to practice, but you're going to have to refrain from marking them up. You're going to have to still, like, pull out your computer, pull up a Word document or something, and I would recommend getting a book stand or something if you don't already have one, so that you can have the book with the questions propped up next to your computer, so that you can approach even the books the same way as you would be approaching the online version, right? So you would have that set up, and then you're gonna have to type out the like Abby, daughter of Betty, Chad, daughter of Dan, um, and then do your timeline and get ready to type that out. That's the only thing you're going to be able to do to keep these things straight. And that's why they are giving you the virtual scrap paper instead of making you just do this without. Because I know when I was taking the bar exam, I actually preferred the online questions because I had the ability to mark them out and just focus on the answer choices that I wanted to focus on. And I just kind of trained myself not to make notes and not to notate, and just to try to anticipate what the question was going to be. So I think one thing that can help you is to kind of flip the script on how you've been approaching MBE questions. Many people will tell you you should read the call of the question first, then go back and read the fact pattern. Some people will say you should read the call of the question and all the answer choices before you go back so that you can read with intent. I think, and this could be controversial, so don't at me, but when it comes to the fact that we're only going to be seeing this material online and you really don't have time to be scrolling ceaselessly up and down, I would recommend you don't even look at the call of the question first. And the reason is, what I want you to do is I want you to rethink how you approach the MBE. I don't want you worried about, oh, I've already got my heart set on one of these answer choices and now I'm going to try and find the facts to support me. What I want you to do is flip the script, look at the fact pattern, read it carefully, and as you're reading, I want you to be thinking, why are these facts relevant? What is going on here? Why do I need to know the relationships between these two parties? Why are they giving us these dates? Why are these dates relevant? What are they possibly going to be asking for? So what's happening here? What I want you to do is use your ability to think like a lawyer, because you're all lawyers. I don't care if you've got a license or not. You're all lawyers in my book. I want you to use your analytical lawyer skills to anticipate what you think the question is going to be before you see the call of the question. I know sometimes it's difficult, but you might be able to scroll down to hide it. So I would recommend trying to hide the call of the question and just look at the facts, reading the facts, thinking carefully, and read actively. Don't read passively. Don't just skim through. Read, like, slow down a little bit. Most people tend to read the fact patterns too quickly. So slow down a little bit, and as you're reading, ask yourself questions constantly. Do a mini Socratic kind of approach in your brain. Why is this fact here? Why is this date important? Why are these two parties mentioned? Why is the relationship here important? What's going on? And then think, oh, well, based on these facts, it would seem that they're trying to find out if this is a psi-prey issue, or if this is a situation where, like, whatever, you know what I'm saying? Like, you should be thinking in your brain, like, why are we talking about this? Why are these facts here? The only reason they could possibly be here is because they want to talk about this particular type of rule of law. And that's what's getting applied here. So you should be able to anticipate that. Now, when you're holding the question in your mind that you think is going to be the question, now look at the call of the question and see if it's similar to what you were anticipating. And if it is, you should already have an idea of what the answer will be. Don't look at the answer choices. Before you look at the answer choices, I want you to think again in your mind, okay, so now that I know what the question is, now I know what the facts are, what should the outcome be? You should have an idea of what the outcome should be before you look at the answer choices. And then what I want you to do is pick the answer choice that is closest to what you think the answer should be. One of those four should pretty closely align with what you've already determined should be the answer. Now, this isn't going to be 100% effective because there's going to be some questions, like you'll probably get a couple rule against perpetuities types of questions. Just put A and move on. Who cares? Don't waste your time. It is not worth it. When you see a super duper long pattern and you're pretty sure it's rule against perpetuities, do not waste your time. Put A and move on, or whatever letter your bar prep company told you to put. Everybody in America, come together, decide what letter you're going to put so you can completely neutralize these questions, because I don't even understand why they keep testing it, because nobody understands it except for 5 people in the entire country, and those people are jerks. So be strategic in how you're approaching these questions, because we know that you just really don't have time to be typing a bunch of shit, to be looking backwards and forwards, to be scrolling up and down. There should be a limit to how much you're scrolling. There should be a limit to how much you're going backwards and forward. And you should be able, if you stop and think and ask yourself, why is this fact here? Why would it be important? What area of law is this going to be addressing? What should the rule be, and how will it apply? You should be able to come up with that information in your brain before you look at any of the answer choices, okay? So I know this is not an ideal approach, because there really is no ideal way to do this. The only other thing that I would recommend is, if you are not used to practicing online, if you're a book person, I know a lot of people just get those giant question books and just go through them like crazy, or you've done practice tests but they've given you the booklet and now you don't have a booklet, you don't have a Scantron, you don't have paper, pen, you don't have anything. So I would recommend that in the time you have remaining, you just start training yourself to work like completely without a net. And by that I mean, if you have access to online question banks, use that exclusively to practice until you're out of questions. Believe me, you probably will not run out of questions. At this point, where we're at, some people are taking the bar exam in 10 days. Some people are taking the bar exam in a month. The likelihood is, if you have a question bank, you're not going to run out of those questions. You're just not. If you're fortunate enough to have resources, there are bar prep companies that offer additional question banks. So I would recommend, if you have the resources and you can afford it, and you do not currently have access to question bank in your current bar prep, I would recommend, like, beg, borrow, steal, do whatever you got to do, get that money. Usually it costs, less than $300 to get a question bank, and usually it's between 1,500 or 2,500 questions, additional questions, and that'll get you to the end of the bar prep period. If you cannot afford to use a question bank, I mean, I think at this point, the best thing that you can do is use the techniques that I've outlined for you with the books. And like I said, put the book next to your computer, side by side, on a book stand, and do not touch it. Because you're allowed to highlight, sure, you can have the highlighter. That's the only thing you're allowed to use. The only thing you're allowed to use is a highlighter, and be very judicious in your highlighting. But no, if you practice that way, that's not going to be a accurate kind of practice. I mean, the only way that you can really master this particular type of testing is to test in the native format. And so if it means get up a GoFundMe, pass the hat around at church, sell lemonade, whatever it is, drop your Venmo on Twitter and let everybody, do some crowdfunding, whatever. I think really, I just don't see a valid way to master the MBE in an all-electronic format if you don't have access to all-electronic questions. And it's really important that you test as much as you can in that native format, one way or another, because even if you get to the point where you're able to do them from the book without doing a lot of writing on the book, it's still not the same as being comfortable, like, deselecting certain answers or highlighting a few things and then using the virtual scrap paper. So I would highly, highly recommend that you move all the way from paper to virtual. That's really the only thing that I can think that can help you. So that is kind of what I'm thinking, and I know a lot of these techniques are going to sound weird. They're going to sound maybe controversial. You won't have heard this from a bar prep company because they're not going to put themselves out on the line and make these it wouldn't make sense for them to put themselves out like that. It really wouldn't make themselves. It wouldn't, because you're going to come at them and you're going to be upset with them. I'm just some chick on the YouTubes. So take what I've got with a grain of salt, use it or don't use it, but please feel free in the comments, and I will be checking the comments. So if you have questions about what I've said here, if you want to set up a time to talk personally, I'm very happy to do that at no cost to you. Or if there are other questions that about doing an online MPT or an online MBE without scrap paper that you would like me to address, I'm happy to make another video. That was episode 1 of Soft Apocalypse Bar Prep. For everybody out there, stay safe, stay well, and hang in there.